Okay, welcome everyone to MidPenn Legal Services Protection through Powers of Attorney and Other Documents. MidPenn Legal Services is a nonprofit public interest law firm, and we provide free civil legal services to residents in 18 counties in central Pennsylvania. Our clients are primarily individuals living at or near the poverty threshold and survivors of domestic violence. You can find out more about our work by visiting our website, www.midpenn.org, or visiting any of our social media platforms. Our social media handle is Legal MidPenn, and you can find us on Facebook, Instagram, and Twitter. This session has been made possible by a grant from the Pennsylvania Interest on Lawyer Trust Account Board and is being recorded. It will also be available on MidPenn's YouTube channel. Attendees are in listen-only mode. If you have a question, please enter it in the chat box. After the session, if you have a question, feel free to message us on Facebook or email us at development@midpenn.org.
Thank you, Linda. Hello, everyone, and thanks for joining us today. A very, very interesting discussion we will have. I hope you came equipped with a lot of questions, and it's my pleasure now to introduce Daniel Handley, who is our attorney from MidPenn Legal Services. Daniel Handley was raised in Delaware. He served for 2 years as a missionary for the Church of Jesus Christ of Latter-day Saints in Phoenix, Arizona, where he worked closely with community leaders to serve low-income populations. After graduating from Brigham Young University with a BA in history, he earned his law degree from Penn State Dickinson School of Law. During law school, he volunteered with Utah Legal Services, again serving low-income populations. He also interned at an elder law firm where he focused on preparing powers of attorney and helping victims of elder financial abuse. And with that being said, I will turn it over to Daniel and kick off the discussion. So thank you.
Well, thank you very much for that. And welcome, everyone. Good afternoon. So today, we will talk about powers of attorney and other planning documents so that we can better understand what a power of attorney is and what it is not. So before we begin, here's the disclaimer. This is an informational session and not legal advice. If you have specific questions for your situation, want to speak with an attorney that can give you legal advice. Like was mentioned, Project SAFE is made possible through IOLTA, and the Project SAFE attorney focuses on conducting education and outreach and provides legal representation across all of MidPenn's service area. And we focus on the low-income elderly and disabled individuals. So I get to help with those topics. This presentation has 3 parts. This part 1 is planning ahead and why we need advance directives. So an advance directive is a written legal document that instructs or authorizes others to act in your behalf if you should experience a medical emergency, or if you become incapacitated, or you don't wish to handle your personal, financial, or medical affairs. So basically, advance directives are a way of writing down your instructions in advance of the time when you need, so that someone knows your preferences. You may never need an advance directive, but putting your instructions and decisions on paper in advance is one of the most important things you can do to protect yourself and your family in the event you are unable to make decisions about your financial and personal or medical affairs. So it's important that these things are done early because no one can predict the future. Accidents can happen at any time, Illnesses often occur as we age. So terminal illnesses, disease, Alzheimer's, dementia, um, and other irreversible medical conditions. We want to prepare these documents before we need them so that when these things, if they do happen, we are ready and prepared for them. The types of advance directives that a person should consider is first the financial power of attorney. Now, this authorizes someone that you choose, and that person's called an agent, to handle your affairs or make decisions for you. And this is the focus of today's topic, so we'll dive into that a little later. The second advance directive is the living will. And this document conveys your wishes about future life-sustaining treatment. If you have an end-stage medical condition, if you've suffered irreversible brain damage, or entered a permanent unconscious state. And this deals specifically with your wishes about life-sustaining treatment. The healthcare power of attorney is like the financial power of attorney in that you designate someone, a healthcare agent, to make decisions for you. And so the healthcare power of attorney and the living will together, oftentimes done together, they make up the advance healthcare directive. So if you haven't planned or prepared, then certain things can happen. Anyone who is interested in your welfare can petition the court to file a petition for a guardianship. And so the guardianship, a guardian is someone who's been appointed by the court to care for your person or your property. So this is a court proceeding, and it can take time and it can be costly. So what's wrong with having a guardian? Well, they can be time consuming, as I said. So it can take time between an emergency hearing to a final hearing. It's based on the court's availability and when the parties and attorneys can meet. So if there's a medical emergency, then time should not be wasted. The guardian may not be the person that you would have chosen to be your agent. And so they may not understand your wishes. They may not, they'll be acting in what they think is your best interest instead of you talking with your agent beforehand. And then a guardian can have limited or full control over you and your property. And they can have temporary control over that, or they can have permanent. And it can be difficult to get rid of a guardianship. Part 2 is where we talk about the power of attorney specifically and talk about its requirements, what is involved so that we can understand what it is and what it does. So I often hear people say that I have a power of attorney, but they are referring to the person who is designated to make decisions for them. Now, the power of attorney is the document created. The power of attorney names a substitute decision maker, aka the agent. And so the power of attorney generally avoids the need for a court-appointed guardian. A court-appointed guardian may still be needed if the agent does not do what they're supposed to. The guardianship is a public event. It's a public proceeding, whereas you would meet with your attorney and create a private power of attorney, and it's relatively inexpensive. So the power of attorney is the document. And the principal is the person granting the power and authority of the document. The agent is the person appointed to act on the principal's behalf. One really big requirement of a power of attorney is the principal must have capacity. And we hear this as be of sound mind. So if the requirement is that you have to have capacity to make a power of attorney, you need to prepare one before you lose capacity. And the law assumes that we all have capacity. When you meet with an attorney to create a power of attorney, the attorney will ask questions to help you, to help determine whether the principal has capacity. The principal needs to understand the purpose of the document, needs to understand the role that the agent plays, why they need the agent. You need to understand the powers and authorities that they are granting the agent, because there's a lot of responsibility, a lot of weighty powers that go with this. So a well-drafted power of attorney eliminates delay, complications, and expenses of petitioning the court. And it ensures that your agent has the authority to handle your affairs. You can't just go and act in somebody's name. Legally, you have to have the authority. So a well-drafted power of attorney protects your family from trying to do things in your name without your permission. So power of attorney gives that permission to your agent, which is oftentimes a family member. It's helpful to know what types of things an agent can handle, so that a principal can start thinking about these things so that they can decide what they would want to put in a power of attorney. What authorities do I want to grant my agent? Some powers that are able to be granted may not be applicable to that principal's situation. So the agent can prepare, sign, submit taxes. They can access income and assets to help pay bills. They can manage investments. And so you think about, as a principal, you think about what things would I need my agent to be able to handle so that my agent can do everything that I need them to do. Working with low-income individuals and the elderly, the main reasons for having a power of attorney is if the medical emergency happens and you want someone to be able to handle your affairs while you're in the hospital for an extended time, or if you're in a rehab facility, you don't want your bills to go unpaid or other things like that. You want them to have the authority, your agent to have the authority to take care of those things while the principal is unable. So our focus is to have power of attorney that is appropriate as a planning tool. Preparing a power of attorney is like having a backup for yourself. I can make, while I have capacity, I can make all the decisions that I would normally do. But having an agent under a power of attorney creates a backup. So in case I am unable to make those decisions, the agent can then step up and step into my shoes and help take care of my finances, specifically with the financial power of attorney. There are terms in the next few slides that a lot of us may have heard before. So I'm going to talk about the different types of powers of attorney and which ones are appropriate for long-term planning. A limited power of attorney, it is very specific. I bought a car and I authorized the dealer to be my agent to handle everything to do with the car purchase. But when that car purchase was finished, that agent's authority ended. It was only for that specific instance. So banks use them to authorize transactions and things like that. And so if you only have a power of attorney that's good for one specific instance, then it's going to be insufficient. The general power of attorney is the one that's appropriate. It goes throughout the principal's lifetime. And this is the one where we can grant very broad powers and authorities to our agent to ensure that they can handle everything that they need to. You can have a power of attorney that lasts for a short amount of time, or for a specific amount of time, such as only if you're while you're in the nursing home or facility, rehab facility. The presumption is now that any power of attorney created is a durable power of attorney, which means that it goes beyond when a principal loses capacity. So, and that's the type of power of attorney that we want. If the principal loses capacity, we don't want the agent's authority to end. We want the agent's authority to continue throughout that person's lifetime, as long as they're incapacitated. So the general durable power of attorney is preferred because it's for the duration that we need, survives the disability or incapacity. It allows for the proper grants of authority, and that's why it's preferred. There are things that can trigger the powers of attorney to take effect. You may have heard of a springing power of attorney. And this is, the power of attorney is not in effect when it is signed, but rather it contains language that says it becomes effective when a particular event happens. Like, this agent can now act for me if I become hospitalized or moved to a rehabilitation facility. This, I'll go back to the springing. This can be a problem because then you have to go forward and get documentation that that event has actually occurred before the agent can start acting. And if there is an emergency where the agent needs to act right away, then it takes time, and there might not be enough time to get the springing to authorize the agent to act. So the non-springing power of attorney becomes effective when the principal signs it, and then when the agent has signed it. And this allows the agent to act right away, and some people are uncomfortable with allowing an agent, especially at my health and my age. It might be uncomfortable to authorize someone that can sell my home or my car. But if I have a trustworthy agent, I hope that they're not going to do that to me, then I've given them the proper triggering effect. They can act as soon as I need them to, instead of needing to go through extra hoops. Yes. Under the power of attorney statute in Pennsylvania, powers of attorney after 2015 need a notice form. And I like to look at what's required. Because if you're going to go through this process of thinking about your life goals, what's important to me, my values. If you're going to go through all of this and meet with an attorney, you want to make sure that it's valid. Okay, so you don't want to go through all this process and this time to then have it not be upheld by a bank or by a court. You want this to be valid so that your agent can take care of you. Now, the notice form summarizes the powers and duties of an agent, and the principal signs the notice form, indicating that he or she understands the contents of the power of attorney. And we'll take, on the next slide, it's a lot of text, but it just is an example for us to look at of what's included in the notice form. And so it's usually bolded or all caps to bring attention to the principal that, hey, this agent can sell your house. Do you understand that they can do this? And that may be a good idea later down the road, but just so that you understand what's going on. And it gives cautions and explains a little bit of what the agent can, they don't have to act, but when they do, they have to act for your benefit. And then explaining that it continues through the principal's loss of capacity. The top paragraph mentions the agent has to act in your best interest, act in good faith, and only act within the scope of authority granted them. And then the bottom paragraph, again, talks about how this can be a broad grant of authority, and make sure that you choose someone wisely to be your agent. It talks about how the court can take away the powers of an agent if the agent's not acting properly. And then if you don't understand the form, having an attorney go over it and explain it. And then lastly, the signing, acknowledging that you have read or had explained to you the contents. Now, the acknowledgement is what the agent signs. So for a power of attorney to become effective, have that agent be granted the authority, they have to sign and say, yes, I will act as an agent, and that they promise that they'll act in accordance with the principal's best wishes again. They'll act in good faith. They'll only act within the scope of authority that they have been granted. This language is important, which we'll talk about in a little bit, but just remember that language. Other important parts about a power of attorney, they need to be state specific, right? They need to be valid in the state that they're created in. And for Pennsylvania, a power of attorney needs to be witnessed by 2 people, and it has to be notarized. And the notary can't be a witness, and you have to make sure that all the people line up. So just like we said, you don't want to go through even the execution ceremony and it not be valid. So you make sure that everybody knows their role, and this is what the attorney will help with and make sure that it's all good. And what you should do after you complete the power of attorney is give a copy to your agent. Now, our next presentation in a couple of weeks is going to talk specifically about agents. So I'll just mention it briefly here, but you should, the first time that your agent is hearing about this power of attorney is not when you're asking them to sign the acknowledgement. Preferably, you've gotten their permission. You want to check with them to make sure that they're up to the task and that they understand what authorities they have and what authority they don't have. So you want to give a copy to your agent. You want to have a copy, but you also want to give a copy to all the financial institutions with which you do business, so that they're not seeing it for the first time after the principal has lost capacity. You don't want your agent to show up and then it not be upheld because, or just time passing because they need to look over it and make sure that it's valid. You want the financial institutions to know that this has been a thing. It's in your file. They know who your agent is, so that when your agent shows up to do business, they know exactly what's going on and there's no time delay. And then also, a lot of banks will want you to complete their own form. They should accept a validly executed power of attorney, but a lot of times they have their own form that they want you to fill out. So as long as, I say if we're already going ahead and doing this planning, let's go the extra step and prepare everything that we need. So go to all the banks with the principal and make sure that all the forms are filled out so there are no hiccups. And that way, when the principal loses capacity, everything is in a row and lined up. So we talked about this before, but a power of attorney should be completed as soon as possible because we don't know when we'll need it. And we can only sign it if we have capacity to understand the powers that we are granting. So a power of attorney, there are different rules for the power of attorney, healthcare power of attorney, or living will. But pretty much they can be altered at any time. They're not set in stone. So when you want to make a change, you should discuss it with your attorney. And then when it's been executed validly again, you'll want to give updated versions to all the people that received the previous copies. That would be confusing to me if I had a power of attorney on file and then an agent comes in with a more recently executed one. And then I have to compare the two and make sure which ones. So make sure for living wills, the physician has one, powers of attorney with the financial institutions, and make sure that your agent has a current copy. Some people execute all these documents and then lock them away in their safes and they don't talk to anyone about them. That's a really good way to have your wishes not followed if no one knows what your wishes are. Revoking or just completely getting rid of one, a good practice is if you want to remove an agent that you put a notice in writing that they no longer have the authority to act as your agent. Because if they don't receive notice, then the agent can still act on behalf of the principal. So you want to give the agent notice. And then as far as living wills go, you can kind of talk to your physician at any time, as long as you're able to express your desires. Some common reasons for changing or revoking advance directives. It's recommended that you update these documents when at least every 10 years. Look at them when there are births or marriages in the family, when a major medical condition happens. So we review these documents when kind of major life changes happen so that everything's up to date. And we can make these changes. Reasons that we might want to is because there may have been medical advances and there may be some treatments for some conditions that we find, we wouldn't want to do that, but then they come up with a different treatment that is more acceptable to us. Or something that they thought was terminal is no longer terminal. So you may want to receive that aggressive medical treatment. Sometimes people move away. So your agent can move, or you can move, or So we'll talk about agents in our next presentation, but we want someone who can be close by and handle things. Sometimes relationships change between family members, between agents, and so someone who may have been a good agent at the time you made the document is no longer, or if they've passed on, then want to make sure that the document has a provision for that. And attitudes about treatment can change, so we can make those changes to our documents. So this is a look ahead to our next presentation, where we'll talk about choosing an agent for your power of attorney. So I'm giving this as a little taste to have everyone come back for part 2. So because this is one of the most important considerations for the power of attorney, because you can create a really awesome power of attorney that grants all the authority, but if you have a bad acting agent, then it's no good. Part 3 is preparing planning documents. So an attorney is not required for these advanced directives that we've talked about, but of course they're recommended. Just like, if you have an electrical problem or a plumbing problem, I like calling in experts because they know what they're doing. They have expertise in relevant areas. As far as advanced directives go, attorneys can have expertise in elder law, estate planning, and advanced directives. And then they'll have the experience in drafting documents that reflect your unique circumstances and your wishes and values and your life goals. Preparing planning documents online, lots of places you can download a form, and these are discouraged because they're usually general and not state specific. So they may not have the notice form, the acknowledgments. They may grant your agent too much authority. They may grant your agent too little authority. So it won't be unique to your situation. And it might not have the proper execution requirement, so that it's not valid when you go through all of this. So these do-it-yourself forms are discouraged. And so when a person qualifies for MidPenn's services, they can receive help in drafting a power of attorney, selecting an agent, removing a bad agent, looking over documents that have been created in the past, and helping with elder financial abuse and exploitation. And so when someone meets with an attorney, they'll want to have thought about their needs, their goals, their wishes. And so clients will want to be ready to talk about these with their attorney, and they'll want to have names of agents ready. So next presentation, we'll talk about why having names of agents ready is important. So that is the end of the presentation.
Thank you, Danielle. This was very informative and educational. Definitely, I know for me it was. I would like to ask the attendees if they have any specific questions on any of the parts that Danielle covered regarding power of attorney and other documents. Please feel free to put them in the chat or under the question and answers box. But as you can see, we're available online, and as well you can reach us via our phone number displayed on the screen. Follow us on social media, like us, If you would like to, if you have any further questions, if you think of a question, drop us a message. We would be happily get back to you. So I want to ask actually Daniel a question. Daniel, what is the number one, like the top priority question that someone should ask themselves when they are thinking of creating a power of attorney, of designated someone as a power of attorney?
The number one question that they should ask when selecting an agent is that,
Yes, yes, like the first thing that they should have in mind.
well, when selecting an agent, the number one question I would think is, can I trust this person? And we will have our second presentation will go very in depth on trustworthiness of agents. But can I trust this person? Can they handle things under stress? Are they good at managing money? Can they handle other people's money? So those are some of the things that a person, when wanting to select an agent, they think about. Is this person good with managing money, and can I trust them?
Gotcha. That's a good point. Trust is very important, right? If you're going to have your life written by someone. So I see that Linda also put in the chat the PowerPoint file. Feel free to grab it from the chat. It is available for you there. We will also follow up. If you registered the webinar, you will receive a link, with the recording, and we'll be happy to drop the PowerPoint to any of you who didn't receive it. And with that, we will have another session of, with Daniel talking more about power of attorneys. And like he said, to characterize, what that agent should be on the trustworthy side and, everything else that needs to be checked. So with that, if there are no further questions, thank you for joining us today. And we hope to see you again soon. Thank you so much. Have a great day, everyone.